What a pleasure. Of course. I know. Pleasure to see Matt. What a pleasure. Yes, of course. I'm so happy you're here. Congratulations. No, I'm just a child. Sure.
Yeah. Maybe if they were in high school. Yeah.
Well, I guess we still go through the work first. We all got some with the
the person receiving the confirmation ends up doing whatever.
Nope, just microphone.
Check 1, 2.
I'll give you one more. I mean, but the thing is, in the next 3 or 4 more homes.
Hi, how you doing?
Good, thanks.
For the ballots? Okay, great.
I know.
Yeah, it's the one receiving the handshake, you only do that.
I actually did it last Thursday. Well, I went out and I'm gonna get a house reading. Yeah, I did my memo Friday, so I'm so confused. It's like I did my memo until like 12:03, so I'm not like.
Oh, Sean. Oh my God. That's good. Not at all.
Yeah, I like. Me too. Like Saturday was like half party and I did do it. Because I was like, what if I know the National Law Journal I need a break, so I just like marathon 5 episodes of anime.
Nice to meet you. Yeah, I was actually thinking it might have been you when I was saying. No, it's no
Well, anything I was thinking everyone's I'm finding that I'm trying
Is David
I said how I had
out of breath. That's supposed to.
I definitely plan on doing it. There's a lot of materials. But if I get all the materials for it, I don't see why. I'm not gonna do that part because I'm gonna do the same format as the same format as
I'm really thrilled. I'm thrilled. You can email your father. Yes.
It's in fact the first engagement that I'm meeting you.
Yes, I know your father from childhood. Yes, and your grandfather was a very great man. He was my benefactor. So special, very special to you. So look forward.
Yeah. See you.
See you. Oh, pleasure. You're from Calcutta? You did your religion?
So I grew up with it.
Okay, you did the JD? Don't worry, by the time I go back, things will be better. I think we all need it, but I just wish it I want to stay for another year. Then I think a lot of things could have gone away at the same time. But since, I was not an elected member, I was an ex-official and I was checking, what can I hold on to the job? But things will change. Look, there are actually obstructionist issues, but I think that we all persuaded. It's really part of this obstruction is caused by government. The top of the table. Hi. Oh, we're from here. What a pleasure. Of course. Congratulations. I saw that you're now teaching here. Yes, of course. Yeah, great. Well, I hope so. I look forward to it. Sure. What a pleasure. I remember. Hi. Thank you so much. What a great pleasure. What a pleasure.
Yes. Oh. Yes.
Okay. Sure. Yeah, the same. Sure.
So what I'll do is I'll just make it over you.
Now.
Well, that's great to see you.
I'm gonna have a check.
Do you want anything?
Lovely fella. Hi, how are you? Look at it. All 2 years here. I'll tell you, as soon as I finish with this. Yes. Okay. Tremendous work they done now, the whole and one of the things which I'm going to tell today is how are you? Of course, how are you? Pleasure meeting you. I know. Thank you very much. Thank you. Hi, how are you? Oh, come on. Of course. You're also related, so of course. Do it.
All right. You ready? Absolutely. All right. So welcome everybody. Why don't we get started? It's wonderful to see such a terrific crowd here, appropriately to see such a terrific person, but Gopal, you should know this is really terrific because you're competing with a sitting United States Supreme Court Justice who's speaking also at 12 o'clock today. So the fact that you packed them in says something about you, and it also says something about the importance of India and what we recognize as our need here in this country to know more about what's going on in India, and there's nobody better qualified to talk to us on a whole variety of fronts. We could spend the whole time talking about his many accomplishments, former Solicitor General of India, former head of the Bar Council of India, distinguished senior advocate. We could go on and on, but I won't. I'll just say this, that I've now been coming to India over the last few years, working on a research project about the development of the market for legal services there. That's part of this big project we call Globalization, Lawyers, and Emerging Economies, or GLEE, as we like to call it, after the popular TV show. And no one has been more welcoming and more supportive of our efforts here, a greater friend of Harvard Law School than Gopal. And it wasn't at all surprising to me that in one of India's greatest moments of need, that they called on Gopal to lead really a group of extremely distinguished people to try to wrestle with one of the most important issues facing not just India, but every country today. When Gopal called me and told me that he was involved in this, I said, Gopal, I'll help in any way I can, but I'm no expert in this field, but luckily I do know one of the world's best experts in this field, and that was Diane Rosenfeld, who is our own professor here, who teaches extensively, many of you know, and who has done just pioneering work all around the country and in many places around the world on this issue. And Diane jumped at the chance to work on this issue, jumped in, and has really done amazing work. So let me turn it over to Diane to introduce Gopal a little bit more. Thank you.
For 1 minute. Thank you, David. So among David's talents, he's amazing at connecting people, and this connection to Gopal has been phenomenal, and I'm so deeply, deeply grateful to you for that and for all the work that you do in the legal profession. And my friend Gopal, I won't talk too much about him because that really literally would take up the whole hour, but I just want to say that his heart and mind are so huge and so strong to be in one person. It's just amazing to have the combination of gifts and talents that he does. So I'm very glad that you're here with us to hear from him and what he's thinking about. And it's October 1st, so it is the beginning of Domestic Violence Awareness Month in the United States. And President Obama did a declaration, as he has been doing for the past several years. And in that spirit, and in the spirit of gratitude for what you've done to stop sexual violence and gender violence in India, we welcome you at Harvard Law School, and we're just so very grateful that you and Qatar.
Thank you. My dear and inspiring friend, David Wilkins, Diane Rosenfield, and the distinguished audience. I wanted to teach all my life, but Providence dispensed me with the profession of lawyering. The profession, of course, gave me vast opportunities to study the Constitution and what it meant to Indian citizens, including me. My father, a Harvard man, got admitted to the Supreme Court bar in 1954 and chose to witness and participate in the growth of constitutional law. I felt his passion for the subject. I told my wonderful wife, Geeta, that to come and speak at Harvard was one of my innate desires, but she, with her characteristic counsel, said that the inner preparation is necessary. And to speak at a subject which is the fundamental article of my understanding of society and the purpose of government, it required considerable reflection on history, philosophy, and psychology, which are necessarily intersectional subjects. So here I am. The following words are relevant to describe our present society. Turning and turning in the widening gyre, the falcon cannot hear the falconer. Things fall apart, center cannot hold. Mere anarchy is loosed upon the world. The blood-dimmed tide is loosed, and everywhere the ceremony of innocence is drowned. The best lack all conviction, while the worst are full of passionate intensity. W.B. Yeats wrote this in his Second Coming. But strangely, I find that these words seem to have continuous historical relevance and significance. In the subject which we have today, which is very interesting, which is democracy, and you have on the other side what is called due process. But both these are concepts which are originating from what we call as a constitution. Now, the Indian Constitution is one of the most historical products, purely in terms of history, circumstances, valiant human effort. First, it was the need for a self-determining society and the insistence that there must be an indigenous constituent assembly which must frame the constitution that took such a long time to get the British to cede this demand in 1947. It was marked by relentless satyagraha, and as K.N. Munshi said, it was a pilgrimage to freedom. Those who participated in drafting the Constitution were not only inspired men, but they had the benefit of studying comparative constitutions and also frame the fundamental values which the Supreme Court later called immutable. The first which you see on your left is this immutable value which is called democracy. The second is what is called due process. But why is it that democracy is going to be conditioned? Because democracy is not going to be simply about majoritarianism. Democracy is not going to be unconditioned. It is not going to be merely a brute democracy. So how do you qualify democracy? You qualify democracy by due process. And I'm going to argue that this expression, due process, has a completely different componential meaning in the Indian context. It is not about formal compliance with law. It is not also about substantive compliance with law, but the due process means literally searching for the constitutional purposes in every executive and legislative action. Let me see whether this interpretation is going to leverage in what we call as a just outcome. Now, the expression due process initially was understood in India as no more than formal, textual compliance with the articles of the Constitution, which meant that it was a formalistic interpretation, and the courts would be satisfied with the boundaries of formalism. Now, we find that in America we have a strong, shall we say, powerful school of thought which calls this as textual and literal interpretation. And the argument against what is called as purposive interpretation is that it allows extraordinary latitudes to judges based on subjective ideas and subjective idealism, which could lead to a transgression of the doctrine of separation of powers. Now, we also need to appreciate that due process and democracy put together are meant to produce results. We used the topic just outcome, but just outcome was really a larger expression. It was meant to embrace all the tenets of faith which you find in the preamble of the Constitution. Now, these tenets, according to me, are very valuable. They are valuable not only for the purpose of evocative, rhetorical empathy, which these words have in themselves, but they also have a tremendous capacity to guide both democracy and also due process. Let's look at what do we mean by just outcome. So we have, first of all, justice. And what is this justice about? Is it justice in the due opinion sense, based on ethical independence and, shall we say, the benefit of cooperation? Or is it that justice is going to be both individual and social? Now, when you look at individual and social justice, how does an individual get justice unless his liberty and freedom is completely guaranteed? How does society get justice unless and until you have what is called political, economic, and social justice? Now, this is really the just outcome we're talking about. So, one of the interesting points is that although political class in every society always strongly defends its pedigree to authority, its ability to depend upon what is called as a majoritarian election, but having said that, their authority to act is not only on the basis of the old jurisdictional rules of ultra vires, but is conditioned by the just outcomes which are a part of the constitutional charter. That's why I chose this subject, because this connection needs to be made for the purpose of understanding the functioning of the three organs of the state in India, and what happens when one of the organs is compliant with the letter but hardly with the spirit. Then what happens? Are we going to have what is called a constitutional atrophy, or are you going to have a collapse of society? And this is something which we will discuss together. Now, if a constitution is interpreted to incorporate due process in some articles of fundamental rights, I'm going to argue that the entire constitution operates as a limitation on acquiring political power as well as the manner in which it is exercised. So my theory is that the whole of the constitution, not simply a few articles which are called fundamental guarantees, really import the theory of constitutionalism. If constitutionalism meant that there was a limitation on political power by and according to the Constitution, it is the entirety of the Constitution which will be the limitation. This is very important to understand, because here we come again to two strands of thought. One is the textual, the literal, and perhaps the surreal. The other is that you have not only the textual, but you have an underlying character of the text. Now, the character of the text may really have everything to do with the outcome. The character of the text or the purposes of the text may have all the connections with due process. And let's examine this at every stage in the working of the Constitution. Normally, we look at the concept of due process when it comes to the trial of a terrorist, when it comes to a criminal offense, when it comes to speedy trial, when it comes to denial of equality of rights under the law. Well, I'm not for a moment minimizing the importance of any of these, but I think we should relegate it to the second half. The first half is, how do people come into power to discharge their obligations under the Constitution? And this is the first topic. How do they conform to the spirit of the Constitution? That begins, shall we say, with what we call as political character or political theory, but more importantly, we're going to deal with political formations, which are called political parties. And political parties are multifarious, they're colorful, they consist of very interesting people. Their speeches are usually about everything except the Constitution, the due process, and of course this is something which is completely hidden. There is a veil which is drawn over this. So how are we going to look at the political parties which are the first entrance for constitutional governance to satisfy what I call as the expectant character of the Constitution? And I think this is an important question. It has arisen in two recent judgments of the Supreme Court, one of which is, in my view, absolutely right, and the other one is absolutely wrong. And let me take up the first one. The first one said that if you are convicted of a criminal offense which has a sentence more than 2 years, you're disqualified. You're disqualified by virtue of a provision under the Constitution. Now, a Constitution usually prescribes what we call as the de minimis, the minimal criteria. But is the minimal criteria sufficient for the purpose of political authority? Or should there be additional criteria which has to be evolved by Parliament as a part of its tryst with the Constitution itself? So let's take up this first point, that you have a very large number of persons who are in the electoral fray. The figures are pretty alarming. You have roughly, well, we will make it a conservative, 60% of candidates who enter the electoral fray who have criminal cases foisted on them. Some of them are charge-sheeted. Some of them are facing trial. But in a population of 1.27 billion Indians, it looks somewhat anomalous by any theory of calculus or any theory of Malthus that you must rely upon this huge selected category of people to assume power in a representative democracy. So, in the year 2013, the Supreme Court said in a judgment that if a person is convicted, and that too for an offense which entails a sentence of 2 years or more, he is disqualified under the Constitution. And he must vacate. I think it sounds logical. It certainly sounds logical that the Constitution did not expect that the representatives for political authority would be people who had a conviction to their credit. But more importantly, there was a disqualification which would ensue. Now, when the Supreme Court pronounced this judgment, we found that there was a certain degree of welcoming the judgment. Some of the political parties very, very studiously, assiduously maintain a virtue not very characteristic of them called silence. And they were silent about this judgment. One of them said, you know, there are false convictions. False convictions? I've heard of false cases. False convictions? An independent judiciary is not meant to secure false convictions. It's a complete anathema. Well, why don't we give this man one more chance in an appeal? But why is he so special? Is he so extraordinary? Is he so imbued with constitutionalism that he needs this added lease of life? Well, we had arguments. Then the question was that the Supreme Court said that this is a disqualification under the Constitution. Now, if a disqualification occurs under the Constitution, any person without a law degree, much less a JD at Harvard, would know that you would need a constitutional amendment to get over that judgment. But no! Political parties confabulated together and they decided that, well, you know, it's not necessary that everything should be done through this constitutional amendment. We are people's representatives and we can simply pass a law with retrospective effect, and what we could do is bring about a law by which people continue to be in power, and all that is required is that they should have filed an appeal. They just need to file an appeal. If they file an appeal, the law, the traditional theory of presumption of innocence will work to their constitutional advantage to represent people. And, more interestingly, they gave up the idea of a constitutional amendment. They said that a simple amendment of the Representation of People Act was all that which was necessary. But then, we're now dealing with politics. And in politics, you have strange bedfellows. Now, some of the bedfellows may be getting close to suffering a conviction in a few days. How are you going to actually avert this possibility? So they hit upon an idea called ordinance. My word. The Constitution uses very strong words. It says it must be emergent, it must be so important that, the convening of a parliament or a legislature cannot take place. It's then you take recourse to ordinance making power. And very quickly the cabinet passed the ordinance and it went to the president. And the president, by that time, had realized that the chances are that either the Constitution is going to be preserved or it's going to be betrayed, and he expressed reservations about this ordinance, that why is there a need that you need to bring this in within 5 days, 6 days? That's just because one of the political allies was going to receive a judgment in a case which had been going on for the last 6 years. And he had used every book, every rule in the game for the purpose of seeing that it was prolonged. And because he was going to receive a judgment, they anticipated it may be an adverse outcome. And they decided that we must have an ordinance for this, for the protection of the political ally. Well, the ordinance did not come to be promulgated. The political ally received a conviction and has been taken into prison. Now, this is one example of the concept of due process. The due process does not really begin or end with the judiciary. Due process begins with, shall we say, every part of the Constitution, including the way in which political parties field their candidates and, above all, have laws governing such political parties. Well, I told you that there's a second judgment which I think is completely wrong. I want to tell you about that. It's just been pronounced a few days ago. Now, as you are aware, under the Representation of People Act, if a candidate were to offer a bribe as an inducement to vote, then it's called a corrupt practice. Now, if there is the finding of corrupt practice, he is disqualified for a period of 6 years and his election is annulled. As simple as that. But now, we have a political party which says, I promise you what are called wonderful color television sets, 15-inch bright color, and I'm going to distribute this to the electorate. There is a successor government. The successor political party, after this one ran its term out, says, I'm going to give a few grams of gold to young women who are looking for marriage. Now, this is blandishment of unquestionable character. So, somebody challenged it. It went up to the Supreme Court. And the Supreme Court said, our Constitution is a constitution of checks and balances. Very well. This is now a cliche. Everybody talks about checks and balances. But I don't know how strong is the check and how weak is the balance. I haven't figured out. But anyway, everybody says checks and balances. Good. But the court comes to the conclusion The corrupt practice, is meant to be attributed to an individual, not a political party. A political party is a huge body. And why should this poor candidate have to suffer for what his political party promised people? And of course it led to the distribution of television sets, it led to plenty of blandishments, but the court said, this doesn't qualify for a corrupt practice. But a little later in the judgment, the Lordship said, what's wrong with the television set? After all, it helps people to know. It gives them information. And it is, after all, not too unreasonable distribution of the material resources of the community. That's the second part of the judgment. But by the third part, the judges say, we denounce freebies. No question of it. These political parties shall not and ought not to offer these blandishments. And therefore, we ask the Election Commission of India, by a process of mutual consultation and consensus, to frame model guidelines of conduct for political parties, refraining from offering blandishments. I find that the three limbs, with respect, look highly incongruously placed in this judgment. That's why I said this judgment doesn't appeal to reason. The first one appeals to constitutional purpose and constitutional values. Now let me come to the second point. We have what is called the executive government. As you are aware, it is not only the legislature which enacts laws, but for the administration of government, we have to have what is considered as executive government. As one of the famous scholars, Maitland, on English history, said that the king now has passed on his divine attributes to the minister, and the minister does feel a little bit of the kingly attributes, which is quite true, notwithstanding democracy, notwithstanding egalitarianism. But the fact is that poor Lord Acton got it all wrong. There's no question of absolute power corrupting absolutely. A little power corrupts absolutely. And so you have an executive government which consists now of the minister at the top, and you have plenty of civil servants who enjoy constitutional guarantees. Now they're also meant to observe the constitutional purposes, voice their opinions in governance, and if the man at the top actually is himself not aware of what are called constitutional purposes, or what is called constitutionalism, you are certainly not going to expect any one of these gentlemen to pick up the theory of non-arbitrariness, normativity in action, lack of extraneous consideration, and principles of this kind to guide judgmental behavior or guide executive behavior. So we have a due process which sets in before things come to court, which is in the matter of election of the legislature, which is also in the matter of the way in which the executive government is meant to administer itself. But let's deal with one footnote on the first point. We have a luxurious parliament. We have what's called the Lok Sabha, which is the House of Commons, and we have what is called the Upper House. This Upper House was initially conceived for the purpose of representing the states, because it was a newly formed federation, and it was necessary that people from every state should be able to say something which would affect their state in case there was a dereliction by the members of the Lok Sabha. But later we found that people who never had the courage to face the people by way of direct election They just could get into government through the upper house, through election to the upper house. And that is one of the contentious reforms which India will have to face. That is the upper house, A, necessary? B, should the upper house actually have candidates who in turn occupy important public offices because they have not faced direct election? Now, what is significant about direct election? Direct election is at least some minimal paradigmatic criteria of accountability. Now, if that minimal criteria is not meant of meeting people, facing up to people, being questioned by people, having contact with people, then could you, through an indirect manner, come into the upper house and hold public offices? This is a serious question, and it is a serious question in my view of constitutionalism. Now we come to the third, which is about, shall we say, judiciary. And here we must understand that by a strange admixture of, very interestingly, American law, interestingly, administrative law in Britain, and of course, the fundamental concept of rule of law, the Supreme Court did inject into the articles of the Constitution and into the function of adjudication the principles of equality, non-arbitrariness, above all, reasonableness. Till now, people believed that classification was distinct from reasonableness, but the Supreme Court said that no, we're going to actually combine these values and we're going to make it into a multiple test. And in a multiple test, you can fail on any ground and your action can be invalidated. The multiple test could be, have you taken relevant factors into account? It could be, is there adequate material for you to come to a conclusion? Like even a legislative judgment. Have you looked at the impact of legislation? And what is the degree of ingress which a legislation undertakes upon the rights of people? And if so, to what extent? Is it justifiable? Is it proportionate? So you have multiple prisms through which the court can now look at reasonableness of state action, whether it's executive action, whether it's an amendment, whether it is legislation. And these multiple prisms are criticized as unbridled horses, but they're not. They are not. Because in a certain sense, we all can understand by intersectional disciplines that it is not very difficult to know what are relevant factors which have to be borne in mind. It is also completely within public domain having regard to information technology. What is the kind of social considerations which must prevail with the legislature? And above all, it's perfectly open to the court to be able to examine that is the legislation achieving what we call the just outcome. That is the just outcome. Do the principles which I outlined here, do they support the final legislation? And even lawmaking is a very serious exercise. It is, I'm sorry to say today, it's been relegated to somewhat of a lesser dimension. But lawmaking involves continuous sociological studies, it involves data, it involves analysis, it involves expert opinion, it involves, above all, a certain understanding of why a law needs to be brought in. But to bring in a constitution amendment bill through the night, without any data, without any analysis of the appointments which have been made under the
existing system of appointments, and I'm not necessarily upholding that system, but I'm saying the lack of data, the lack of analysis, the lack of, shall we say, the ability to present before Parliament a sustained argument about a constitutional amendment, I think, seriously undermines constitutional behavior. And now I come to another aspect, which is about denial of rights. Now, when the Constitution was framed, they were very clear that we have to look forward. One of the values in the just outcomes, which I did not mention because I wanted this to come at this portion, is called fraternity. Now, the word fraternity has a certain history to it. It's a part of Article 1 of the Universal Declaration. But why speak about brotherhood? It's because the framers were aware that disruptive forces based on caste, community, religion, ethnic, language, and so on and so forth would have to be dealt with, and there must be a purpose which must be set in front of them, which is that you're first an Indian, you're first a citizen, you're a human being, and then you may be anything else. This paramountcy of fraternity is indeed one of the most important etchings of the Indian Constitution. And one regrets to say that in today's political calculus, the electorate is actually divided on the very criteria which the Constitution forbade you. The Constitution said that there will be no discrimination based on caste, sex, religion. But this is the very basis on which a political calculation is made. That is indeed, according to me, the failure of due process as understood in this larger sense of the Constitution. So it's just not enough to say I'm acting under the Constitution. It's important for you to act out of the creed which has been established by the Constitution. And therefore, this concept of denial of rights is important because it is on account of segmentation of people based on caste, based on community, that people or citizens are led to believe that the exercise of political rights is in a certain sense equal to an instinct of existentialist behavior. And this really means that you are putting democracy upside down. This means that you are using a different alliteration of fear, insecurity, by grouping them, giving them and imparting to them subconsciously and consciously an identity, which is not their identity under the Constitution, but you're giving them necessarily a false identity. And by giving them a mask, it's not the mask of zero, but it is the mask which actually enables them to make a miscalculation in their judgment, because they feel that they need to fight for what is called survival or claim a certain degree of space. Now I come to denial of rights, and in that we come to an important subject which recently figured, which is in the context of gender justice. And we will also look at another aspect, which is social justice. Now, gender justice has come into the fore purely because of compelling events. And these compelling events are absolutely catastrophic events with the human body, like a rape followed by a murder, but they brought into focus for the first time a certain degree of qualitative attention which the state had to pay upon the need for gender justice. Now, gender justice may look axiomatic. Gender justice is guaranteed. But is it enough that a constitution guarantees? Is it just adequate that a constitution speaks the right words and punctuates them correctly? What is necessary is that in order to see that a constitution is a manifested constitution, you have to treat it as a living constitution. Granville Austin says, of course, that a constitution is inert, but it has ultimately got to be administered by human beings. It's quite true. But still there's a gap. There is a gap. And that gap is that one is not a book and the other is not the man who is supposed to open the book. And this gap, according to me, is not simply tautologous. This gap is really the fundamental, shall I say, flaw in thinking about conventional methods of addressing society through the Constitution. Whether you look at Locke's social contract theory, whether you look at Rousseau's purely refined will, which is supposed to manifest in a constitution, whether you look at it through the eyes of Hume, but it is clear that at some level there is a constant dialogue which has to take place between the state and the citizen, and that's possible only through the Constitution. And that dialogue obviously is words. That dialogue is about current day life. But that dialogue does not mean that life is a theater. That dialogue means that there is space for every citizen which the government has to give an account for. So when this ghastly incident took place in December, we saw something very unusual in India. And I want to tell you that there are 4 such incidents. One, of course, was about the independence movement, which was extraordinary in character, tremendous in resolve, and mind you, marked by non-violence, complete non-violence. And, somebody took great advantage of it and incorporated it as an article of faith that in South Africa, when the Truth and Reconciliation Commission had to be constituted, it could be modeled because there was a previous example of non-violence. And there could be confrontation between people, and there could be a cleansing. So it's important to note that when this incident happened, we had for the first time, apart from 47, of course, when the wars took place, there was a certain degree of comity and unity within the country. Then when the emergency was imposed, that was in 1974. And again, people came together silently, and they understood that there was something which was wrong. There was something which was oppressive. There was something which was denial of fundamental freedoms. Well, some people said that, I really liked the emergency because, the trains ran on time. But the same person forgot that his neighbor was picked up at 2:30 a.m. in the morning, and a jeep would come, and he would be quietly taken into the jeep in muffled silence, and neighbors would not even draw the curtains to see what was happening next door. Then, who was that person? Who changed it? It was actually what Stephen Pinker calls as the Leviathan, the judiciary. It was an independent judiciary which kept on entertaining petitions for habeas corpus, tore up all these orders and said, you shall release them, and that is how a transition took place. But the collective will did emerge because of oppression. And after that is then this December movement. It's very, very significant because this time the people who came together were not simply women, they were men, and belonging to all walks of life, belonging to all segments, all sections, all possible hues and colors, elderly women, grandmothers, they all came together. And that very spontaneous protest by civil society was disarming for the government, because government likes conformity, and conformity is sometimes construed as respect. I don't know how these blurrings take place in governmental minds, but their first response was, what do we do with these people? They are holding each other's hands. On the top of it, what they're doing is they're lighting candles in the evening. Oh, they're not even throwing stones. What are we supposed to do with them? And what they did was they said that this must be dispersed. This must be broken. And those who were quiet, holding a peaceful demonstration, were lathi charged by the police. Not a word of regret from government. Not a word of apology from police. And all those who were lathi charged were all leading feminists. They were thinkers who worked for 35 to 40 years on the field for the sake of equality, of rights of women. And they took it sportingly. And one then could see that here was a certain movement by civil society, but the movement was not vis-a-vis rape only. This was only a catalytic point for the purpose of civil society congregating energetically. What they demanded was conversation. And that demand could not be heard, could not be perceived. They wanted a conversation about what was happening. This is not only about rape. Around rape is a multiplicity of denial of rights in respect of women. So if somebody married a person belonging to another caste, a local community could decide to polish off the boy and the girl, what's called honor killings. I wonder what kind of oxymoronic expressions, but honor killings. And there is a law, there's a judgment of the Supreme Court which says Kap panchayats are illegal, this is all contrary to the Constitution. But why is it that there is no political will to deal with Kap panchayats? It's because, again, the political segments depend upon carp panchayats at material times for electoral gains. So, again, what about the entire patriarchal system which denies women a continued basis of equality from the time they are born right up to the time they are individuals capable of autonomy and freedom of choice? These women, this civil society stood for this important issue. And of course, we had some of the most fascinating contributions from all over the world. And of course, not to minimize the extraordinary quality of thought by Indian civil society. The thinkers who had worked on the field for 30-35 years, who ranged from, shall we say, purely intellectual thinkers on the one hand, and those who had been working with sex workers over a period of time. We had a wide spectrum, but there was a dialogue. There was a conversation, and the conversation produced a change. But when a state is unable to undertake a conversation, we must understand that due process is not simply adjudication. It's not possible for courts to actually undertake the solution for every social problem. But in the concept of due process is a certain fundamental framework of values in governance which is to be embraced. And unless and until you have that framework firmly implanted, notwithstanding whichever political party you belong to, governance can well become a bit of a mirage. That's why in the 2007 issue of Time, the Indian democracy was called sometimes chaotic, sometimes robust, sometimes a bit roguish, but no. Democracy can be in peril in more than one way. People think armed rebellion is perhaps one certain way by which you have a negation of social order, but there can be equally pernicious techniques by which you minimize the content of democracy and the rule of law. So when we are looking at just outcomes, and here is an important point I wish to make, because in a society which is 1.27 billion people, it may not be possible to follow one straight line which is going to determine the fates and outcomes of people. It's just not possible. It defies, according to me, the accommodations guaranteed under the Constitution. So, there is a considerable merit in the thesis that you have a heterodoxy of beliefs, assumptions, and segments of society which have different claims. But they require titration. They require, shall we say, innovative thinking. And indeed, I'm surprised that somebody who is actually a psychologist could think of the Leviathan as the first example, feminization as the second, technology and the technical revolution as the third, and fourth, the ability to empathize as an important factor, which is again the need for conversation and dialogue. So due process involves dialogue and participation. But what participation can you expect if out of the total number of days for which Parliament is to work, you work less than half of its sanctioned days. What kind of interrogation in a political democracy can take place if the opposition party itself is somewhat indistinguishable from the main political party? And this lack of distinction or distinguishability passes off under a word called, I don't know whether I should write it, it's called mutual cooperation. I have not understood what is mutual cooperation in an interrogative democracy. And such political compromises can finally land you up with the ordinance, which fortunately has not been promulgated so far, because somebody went into a press conference and called it nonsense and it should be put in a dustbin. Of course, those words looked rather strange but welcome. But once having said that, nobody then had the requisite courage to promulgate an ordinance. So you need a few mad streakers in democracy. And I think they're welcome. They're welcome for democracy, they're welcome for due process. But you do need innovative thinking for being able to forge solutions for an Indian society. And lastly, I wish to add that there is a wonderful book written by one of the professors of Harvard, who was the Eton professor, Charles McLean, on constitutionalism. It's a brilliant book, because rarely do you see a book which has got so much of fidelity to historicity and historical resources. But in this book you find something very interesting, which is that in some sense due process all began with the word jurisdictio, and the word jurisdictio ultimately landed up as the Constitution, and that meant the limits of authority. But the limits of authority are not simply the authority under the textual articles, and therefore, while I admire very deeply the scholars of textualist interpretation in the United States, societies demand different solutions, and a mere separation of powers will just not work in India, because it is not about management of people that a constitution was written for. It was for informing their lives day to day that it was written for. And therefore, the purpose of this strain is a welcome strain. And this argument of judicial overreach, whenever the judiciary finds that there is a corruption scam, or the argument that the judiciary must stay within its exclusive sphere. But this presupposes very responsible limbs of the state performing their functions to a degree of constitutional maturity. Having said that, I would say that the opportunity to come and discuss this subject has been a wonderful experience. And David, before you go, I just need to read only one quotation from Bolingbroke, which I think indicates what is truly the purpose of a constitution. Ultimately, as Bolingbroke said, the constitution is meant to be the parchment of essential values, which is meant to guarantee good government, which is also meant to guarantee, shall we say, the principles of authority. While the criticism of extra legal or natural law overlay in respect of constitutionalism is a frequently propounded argument in favor of textualists, but even the best of textualists, including Dworkin, do admit that ethical independence and freedom for rights in a moral order, we're not talking religious order, is absolutely essential. Thank you, David.
It's good we have a free thinker such as yourself to help us with these ideas. Gopal is actually going to be around off and on for the next several days, and I hope people will get a chance to speak to him. He's actually going to be here speaking again on October 9th at a showcase we're doing with the International Bar Association from 2:30 to 5:30. So if you want to hear more of the wisdom, please do. But thank you again, Gopal. Sure. 5 minutes. Go ahead. But we will talk before Wednesday. I'll find a way for us to talk a little bit about what we're doing. Yeah. Thank you. Anyway, please.
I wanted to ask a question if you actually have a school of thought which says that regarding